police officer?
I'm not a police officer. I'm an
Have you ever been a police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, you are.
Thank you so much. Paragraph 21. Now, paragraph 21, you're saying there are co-conspirators. Confirm?
Yes.
Do you know the co-conspirators by name?
That is part of the investigation, so I cannot reveal it.
No, I'm just saying, do you know by name, not their names. Do you know them by name? Because you have said there are co-conspirators. Do you know them? Not by name.
Okay, she's not asking you to name them.
Counsel, this is what I've been saying. Relax, let me answer. The thing is that
Let me help you to do that.
Yes.
Just say yes or no. Do you know the co-conspirators?
No. The matter is under investigation.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 2. You have said that there was the man of the deceased plan executed and their attempts to cover up. Do you know the people who are trying to cover up the death of the deceased?
One of them is your client.
Do you know that with certainty?
Yes.
Have you provided evidence to that effect of
No.
the attempt to cover up?
It's an investigation but not attached to this agreement.
You have said yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover up?
As of now, no.
No. Thank you. Thank you so much. Thank you, Honor. That will be all.
I think, Your Honor, that will be the end for cross-examination of the witness. We will lay down his. Once he's discharged, his return will lay the basis for our next line of.
Even we would allow a few minutes of re-exam because that follows cross-examination. Mr. Gibbs,
Yes, Your Honor.
my work is to calm you down completely and make you smile.
Actually, I'm calm and composed.
I'm glad. Thank you. Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing. What is the basis of your request for detention continuing today in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now on a scale of 0 to 100%? Doesn't have to be accurate approximation.
49%.
49%. So I can mathematically say this as directly as that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in charge of who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Johnson.
Just one question in the information. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs in the affidavit, whether you have attached anything to show that even the respondent is
the flight risk, why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor, the reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the and this actually to protect the integrity of the investigations. That's why we cannot divert much.
Thank you very much. I believe that is all from our end.
Thank you, Your Honor.
Then allow the next case of
They're bringing the video. How is it?
Now we consider check out 5 minutes.
Depends how.
As we are ready, we're only asking for the benefit of 4. There's Kiton, there's Langat, there's Tusi.
We are fine. We are fine. There are something that have been filed that can be served. There is a moral. Yes, very well.
We'll serve you with authorities. Simply. Our team serve the state together. Yeah.
For the record, I remain Felix Keaton, and also there was another additional attorney at law, Vincent Diebon, also is part of the defense team. Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for continued detention of the respondent. Your Honor, permit me latitude to lay the legal basis. It's a humble submission, Your Honor, that the issue of the question of pre-trial or pre-charge detention has been settled in law. It's well settled in law. And as such, Your Honor, Article 49(1)H and 49(1)G of the Constitution is very clear that an arrested person has a right to be released on bond or bail unless there are compelling reasons. Your Honor, in order to conceptualize and also problematize the issue, Your Honor, permit me to refer you to the statute, which is section 6A of the CPC, of the Criminal Procedure Code. And in order also to contextualize the issue, Your Honor, is that this section 6A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus the Department of the 2016 decision, whereby, Your Honor, in this section, it lays the 2-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the goal. And the other also burden also, Your Honor, rests with the Honorable Court. And as such, Your Honor, under section 6A, it is very clear that pursuant to Article 49(1)(f) and (g) of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays now what the investigation officer must do. First, he must make an application in writing. First, he must produce the suspect in court, which they have done, which we admit that. Then the second thing, Your Honor, is that they must apply in writing, and they have done that through this motion application. But now, Your Honor, the greatest issue that they must also do, Your Honor, is that under section 36A clause 3B, it states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigation have not adduced any cogent reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, they have already gone through the cross-examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, I would refer you, Your Honor, to look at paragraphs 9, 10, 11, and 20 of that. They are building a case that you should continue to detain the respondent because he's likely to interfere with the investigation. We submit, Your Honor, that that is not a cogent reason. And we'll invite you, Your Honor, to consider the authority which we have provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Igonyo has indicated successfully, and I will humbly refer you, Your Honor, to paragraphs 17, 18, and 19 of that decision, whereby the High Court has settled the law that for such a threshold to succeed, the investigation must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Kitiri and Godfrey Kirui, whereby the same threshold.
Your Honor, this is not an objection. It's an humble plea that counsel shares the decision with us, and that it is generous enough that he also points out the paragraph that is paraphrasing, so that we are able to respond.
Your Honor, we have already filed our list and digest of authorities dated in 16th of June 2025, and you can confirm, Your Honor, that they are there. Decisions and everything, they are already coming. It's the last decision. Sorry.
I am looking at the document, sir. I am alert.
Thank you.
The document written respondents list and digest of authorities.
Yes, Your Honor.
I am looking for Mercy Chebet. You have it in the list.
There is another one which is.
So it's not in the list.
No, it's the one you are holding.
Thank you. No, this is the list. It does not have Mercy Chebet. Does it have it?
You already have an authority, the one next to your phone.
You know what we are informing the court is that we didn't have it in the list. So it has added it, that's okay. That's what you're asking. So we can have the paragraph.
Authority, Your Honor. You have already defined it.
For myself to supply.
Yes.
But I think
Yes.
I have the Mercy Chebet.
Yes.
But I don't have the William one.
Yes. Yes.
So far,
Yes. So, Your Honor, if I may.
did you call for the William?
It appears there was an oversight, Your Honor, but I know the court investigation of all the citation of all the authorities, if you have already provided the citation, Your Honor. Your Honor, he has interfered with the flow of my thoughts.
My apologies. My apologies. I am not in that business like my colleagues. They told that must tears.
So what you are saying, Your Honor, at paragraph 17, Justice Gigonyo has laid the threshold and also eliminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the Honorable Court. And they had also a decision which we have also cited, Your Honor, the William Kikir case, whereby Justice also Mutuku said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraphs 9, 10, 11, and 20 of the affidavit. Another link, Your Honor, of the affidavit that, Your Honor, I will humbly beg to refer you to paragraph 24 of the affidavit, whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and also leading to demonstrations, which at times have been destructive. Hence, the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold water is that we will humbly beg to refer you to the same decision of Justice Gigonyo, that is Republic versus Mercy Chebet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge lamented, Your Honor, at paragraph 21, that I have lamented time without number, and again, slide into grief. How and why in this age and time should people take the law into their hands to harm their accused? The community herein is within the territorial jurisdiction of the Republic of Kenya, a nation governed by law and order. And under the Constitution of Kenya 2010, I wonder whether the said community will derive the authority to harm or kill a suspect under trial. No one is above the law or should take the law in their hands. All are bound by the Constitution which reigns. And the community in question should let the law punish the accused. This should stop, and my view is that ground that the security of the accused is threatened by the members of the public or victim family should never, and mark my words, Your Honor, should never be encouraged to be a ground for denial of bail. Otherwise, the court will inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. We say no more, Your Honor. Such ground should fail in limit. The court, the High Court, has settled the law on that. On the other hand, it is even the duty of the police also to guarantee the safety of the respondent. And you have also been told other issues, Your Honor, that they need time to do forensic, to subject the judges to forensic, etc., etc., etc. We submit, Your Honor, that all those reasons that have been given, it can be done without the need for any custodial order. So we submit, Your Honor, that from all the reasons that have been abused, none is cogent and none should pass the master of the law, because they have already done what they ought to have done, and any proposed investigations can be done without the need of subjecting the respondent to custody, Your Honor. Having submitted the link, Your Honor, that they have failed to demonstrate the reasons necessitating further or continued detention of the respondent, Your Honor, we submit on the second link, whereby their statute also, Your Honor, has also given the court the latitude or guidance on what should do. and we shall invite you, Your Honor, to consider section 36, clause 5 of the Criminal Procedure Code, whereby it is stated that a court shall not make an order for the remand in custody of a suspect under subsection 5 unless there are compelling reasons for believing suspect shall not appear for trial, may interfere with witnesses for the conduct of investigations, or commit an offense while on release. So, Your Honor, even having submitted that they have not abused that instrument, there is a duty that the court also must also satisfy itself before granting any custodial order, that there are compelling reasons that the suspect will not appear during the trial. And there is no such reason that has been advanced by the state, Your Honor. And the other aspect of interference, Your Honor, we have already submitted that there are no material information to persuade you that there is a need to further detain the respondent, Your Honor. And in doing so, Your Honor, on the duty imposed on the court in the two-tier threshold, that is the threshold in the second tier threshold, which is the duty of the court, will invite you, Your Honor, to adopt the reasoning of Justice B.J. Otieno. That is a High Court decision in Ramadan M. Hassan versus DPP. It's a 2017 decision, whereby as paragraph 15 of that decision, Your Honor, it is at pages, we are finding that authority. It's at pages 43 to 46 of our bundle, whereby the judge reasons this way, Your Honor, that I must add that a judicial officer before whom an application is presented seeking to limit the enjoyment of a suspect's fundamental freedom akin to the right to liberty is duty bound and enjoined by law and the Constitution to be extra vigilant and not to interrogate whether the facts presented to it melt the dictate and spirit of the law invoked before it and are in consonance with the attributes and general philosophy of the Constitution, which guards against arbitrary and unjustifiable limitations for enjoyment of rights and fundamental freedom. So Your Honor, will humbly persuade you to adopt that reasoning to be extra vigilant in granting such an application, Your Honor, because this being a temple of justice, Your Honor, you hold that mighty sword of Damosil, and you should always strike for the rule of law and nothing else. So having demonstrated, Your Honor, the two-tier threshold, that it fails in every limb, we inversely submit, Your Honor, that on the other hand, there are compelling reasons to release the respondent on bond or bail. And we'll humbly invite you, Your Honor, to consider certain factors. Number one, Your Honor, is that the respondent before you cooperated with investigation. I accompanied him, Your Honor, on the 11th of June, 2025, when he was summoned by the Independent Policing Oversight Authority to record a statement under inquiry. And he did so, Your Honor, and he was released. Thereafter, Your Honor, he also presented himself to the DC headquarters on 13th of June 2025, whereby, Your Honor, he sought assistance to be escorted to the IPO offices to seek whether he is required there or not. And indeed, in my company, he was escorted, Your Honor, and he presented himself, and he cooperated, and he agreed even, and he was really booked at Langata police station, Your Honor. So he has already cooperated, Your Honor. That is a factor which you should consider in granting him, Your Honor. The other factor which we invite you to consider, Your Honor, is that there is already issued in place an interdiction letter, which is duly signed by the National Police Service. And Your Honor, in order to put into perspective, an interdiction letter, Your Honor, is a sua generis document which sets certain conditions, which is replica of the conditions imposed under Section 36A of the CPC. And also, Your Honor, which technically it holds in abeyance the powers of a police officer. In other words, Your Honor, it removes the thief from him. He can't do anything. And from that interdiction letter, Your Honor, which I had a privilege of seeing as anatomy, as well, Your Honor, he has been told categorically that he should report to the OCS, to the LOF police station. So there is also a condition, Your Honor, to demonstrate that is not a practice. There are already safety mechanisms which have been imposed by that interdiction letter, Your Honor. We'll also invite you, Your Honor, on bond and bail. That is to secure the release of an arrested person, as and when required. And irrespective of the issues, Your Honor, whether there will be any intelligent charges or anything, he is still an arrested person within the meaning of Article 49 of the Constitution. And as such, the rights under Article 49 has been activated. And such rights, Your Honor, should be enjoyed to the greatest extent possible. And in interpreting, Your Honor, and in contextualizing the situation, Your Honor, we will humbly persuade you to adopt a latitude that is beneficial to the suspect rather than the state. And in doing so, Your Honor, we will humbly invite you to adopt the philosophy of Justice Kimaru, as he then was, in Michael Rotich versus Republic, whereby, Your Honor, it's an authority from pages 22 to 26. Whereby the judge here in this decision, Your Honor, conceptualized and also reiterated the importance of liberty being in pressures that are personal liberty. Right to liberty should be respected at all times unless there are legal reasons for such person to be deprived of his liberty. And the police should only arrest a person when they have a prima facie evidence that an offense has been disclosed which can result in such a person being charged with a disclosed offense. Your Honor, the reason why we are citing this decision for avoidance of doubt is to reiterate the importance of liberty. It's not about the holding charge. So even in their response, Your Honor, they should not deal with the holding charge. Reasons being, Your Honor, I had a privilege of interacting with this decision, Your Honor, when my then client, Major Rotich, his Lord rest in peace, was arrested and we went all the way to High Court. And the court made certain findings, Your Honor, including one holding charge and his liberty. But the holding charge question, Your Honor, has already been, there is a mutation of law. So that is no longer applicable, Your Honor, and we shall demonstrate the reason why that decision is no longer, the question of holding charge is not applicable, is because of the second decision, which we have also furnished you, that is in Kenneth Omondi, Ocheng, and 38 others, whereby the same judge also reiterated and illuminated the law, knowing that there was a development, because between that Michael Rotich and this Kenneth Omondi decision, Your Honor, there was an amendment to section 36A of the CPC, so which drastically changed the law. That's why we will also adopt the reasoning of the judge, that the reason why this court in the Michael Rotich case required a charge or a holding charge or provisional charge to be presented to the court when the provision is seeking extension of time was first to involve the arrested person of the likely charge that he or she may face, and second to inform the court on the serious nature or otherwise of the charge. So that was the reason in that development of the jurisprudence, Your Honor. So in grounding our application, Your Honor, and also we'll also invite you to consider another factor, Your Honor, that the suspect before you, the respondent before you, is still presumed innocent. That is pursuant to Article 49, I think 52A of the Constitution, whereby he is presumed innocent unless otherwise proven. So no matter the veracity, the public pressure or anything, Your Honor, he is still presumed innocent. So we'll also invite you to consider that one, Your Honor. And finally, also we'll also invite you, Your Honor, to consider that is not a flight risk. Yes, fixed abort, both within Nairobi and also in Eldoret. And it has not even been demonstrated also that is a flight risk. So those are the issues, Your Honor, that we humbly invite you to consider in granting him bond or bail, Your Honor. And we'll humbly beg to ground our application on that under paragraph 3 to 5 of the bond, bail and bond policy guidelines, which will guide you especially on the situational analysis. And we also like to ground our application also, Your Honor, to support the same also, as per the decisions which we have cited, which we have already provided. That is the authorities, especially the Court of Appeal in Jayendra Ginji Malde, was Republic, whereby the Court of Appeal settled the issue and reiterated the constitutional provision that an arrested person has a right to be released on bond or bail unless there are reasonable reasons not to be released. And also the Court of Appeal has also reiterated that now, unlike in the past, even those persons charged with serious offences such as murder are entitled to bail on reasonable conditions. And the applicant here is certainly entitled to that bond, Your Honor. And also on that other issues also, Your Honor, which you have been told that they are compelling reasons to explain the question of interferences, safety and interest, Your Honor. We also humbly invite you, Your Honor, to adopt the reasoning of Justice Mativo in Republic versus Danko Kabale, and I know my learned senior Clifton Better also argued that matter, whereby the High Court has laid the test of compelling reasons. That compelling reasons or grounds ought to be proven to the satisfaction of the court, and mere allegations or possibility is not enough, and bail cannot be refused simply because the accused has been charged with a very serious offense, and that the burden of proving such to the court that there is one or more grounds rests solely with the prosecution, and there is no time whereby the burden can shift to the respondent, Your Honor. We also rely on the other decisions which we have tendered, Your Honor, the Mutai Kimeyu case, which was also a reaction to the Microbotich case before the amendment that we have already furnished to you, Your Honor. And as such, Your Honor, will invite you to decline the application before you because the same is bereft of meat and substance to stand on, and we invite you to unleash a sword of Damocles and to strike for the rule of law and to admit the respondent to bond or bail. I will humbly, Your Honor, suggest that he be released on cash bail or 7,000 shillings. That is what he can afford, because we also know the conditions. And also, Your Honor, in also making a ruling, Your Honor, I will humbly invite also you, Your Honor, to make certain policy or in your dictum to find or to make certain policy considerations. Because the reason why we are here, Your Honor, is also because of the legal edifice of IPOA, which is created under the Independent Policing Oversight Authority Act number 11 of 2011. Whereby, Your Honor, I wish, as the people of the Republic of Kenya, we had constitutionalized or made that IPOA one of the commissions or independent officers under Article 248 of the Constitution. It would have been good. But what the Parliament did in that act, Your Honor.
Sorry, Your Honor. Sorry. You know, Mr. Kito makes a good friend. He has like a law teacher, like my friend Shadrach Bambui. What he's inviting to court to do, which is now justifying, is beyond the jurisdiction of this court. You cannot make policy. So you should just save us time so that we go to what this court can do. Although he had a very good point, but this court has nothing to do with those good points.
It was just an victim observation, Your Honor. And this is why they do that one. They know that thing. What the IPOA Act, what the parliamentarians did was to establish a
Your Honor, we have objected to that time. We are saying that this court has no jurisdiction.
I withdraw, Your Honor, and we humbly beg to submit, and I beg to rest my submissions and raise the questions for me.
Thank you. I really appreciated your industry.
Thank you, Your Honor.
You've not been so helpful.
Thank you, Your Honor.
And erudite.
Thank you, Your Honor.
So I believe the others will not have anything to say.
I know go straight to what my colleague on the other side submitted earlier in the opening statement, and more specifically in the case of Studios Kabichumba versus the Republic. The decision which I believe they will share with you, I've just looked at it and analyzed while sitting here. It's a decision that, in essence, will allow you to dismiss the application today. I'm happy because they are the ones who brought this decision. It's a very beautifully done judgment, ruling. The test that they have been argued by my colleague under Article 49 are found in this ruling. I want to address one of the issues. The first one is the aspect of the investigations. They have made a picture, or they have painted a picture that our client is likely to interfere with investigations. Your Honor, today, the witness in his affidavit and while being questioned in examination in chief and in re-exam, has told this court that they are in control of certain important exhibits which are not within reach of our clients. There's no way you can interfere with those items, exhibits, which are in control of IPOA. Your Honor, the second aspect, which I believe will be addressed by my learned seniors, is the aspect which came out in the affidavit, the issue of forensic analysis. The forensic analysis of the phone, the gadgets, will be done and shall be done in the absence of our clients. IPOA has officers capable of doing that job conclusively without any input from our clients. The attempt by the applicants to say that our clients should be in custody while this process is going on should not be entertained by this court. This court, Your Honor, should abide by the binding decision in Professor Ngugi's decision and release our clients on reasonable bail, which my colleagues have requested, and put even other conditions which our client is willing and ready to abide by. Those conditions, the discretion is with the court. We therefore submit that the application has fallen short of meeting the threshold set by various decisions cited by my colleague and have been supplied to the court, meeting the requirements of compelling reasons. Finally, Your Honor, the affidavit that was filed before this court does not produce, does not even have did not even attempt to convince you for those compelling reasons. With that, Your Honor, I beg my case. I'll allow my seniors to have their time.
You know, with the greatest of brevity, Kangadi, Your Honor, whereas my good colleagues have examined the veracity of the affidavit and bond, my good colleague, Dr. Piton, has laid the legal basis, the premise upon which creates a question with the application before you. I'm just reminded before my good colleague, Mr. Ondeta, submitting its finality to say that the application makes a motion that is before you seeks in prayer A, B, C, D, one, that the matter be had interpreted, which is what is happening right now, which is seeking in prayer B, that the respondent be remanded for 21 days, pending completion of investigations. Praise in prayer C, that the electronic gadget seized from the respondent be subjected.
A. William Kimani murder in 2016, where 3 police officers were convicted of death for the murder of human rights lawyer Willie Kimani, his client Josephat Mwendwa, and their driver Joseph Muiruri. B. Baby Samantha Pendo case of 2017, where 4 police officers were charged with the murder of 6-month-old baby Samantha Pendo, who was killed during post-election protests in Kisumu in 2017. 3. Martin Koome murder of 2013, where police officers police officer at the rank of an OCS, was found guilty and sentenced to death for torturing a suspect to death inside a cell. Among many other instances that the police have been dealt with, family for breach of law and the Constitution. Although we have experienced worse incidents in the past, the progressive nature of our law and policy will soon make such occurrences rare in our country. Incidents such as